Welcome everybody. Those I only have 3 people here with me, so that um, I guess I'm not going to try to call on you as much as maybe I would with a larger group. It's easier with a larger group because then it's easier to generate questions. I'm going to ask the people here, but also the people trying to listen by recording, is come up with 2 questions. It's not as interactive when you're listening by recording, but I want you to pretend like it is. Take a big breath, shut your eyes, and think, well, I'm in conference with my teacher. And in a way, you are, because if you come up with something and then you text me and ask for a phone call, or if you send me a course message, you sort of are in conference with me. So if you're listening by recording, pause the video once in a while, type out a question. You can save it. You don't have to ask it immediately, but save it. And if I haven't answered it by the end of the session, um, send it to me as a question. And those of you, of course, with me, go ahead and ask anytime, because your questions are what the major point is. My presentation is not a thing in itself. It's a thing that hopefully helps you generate questions about what we're doing this week. The question and answer is the best part. The PowerPoint is hopefully a prompt for that, help you come up with more questions. One of the things that creates the logic of the law is to divide each law into elements. Why do we use a text frequently and the course knowledge, the knowledge from the course itself, is because many times, most times, the elements are from very old case law, combination of cases from the past, sometimes the remote past. Negligence has been known since way back before there was the United States, although it was called trespass on the case. But it was basically negligence most of the time. And so over hundreds of years, they got down to duty, standard of care, breach, which means breach of the duty. In other words, not doing your duty. Cause and fact, which is what an engineer would consider the cause to be, or the combination of causes, and damages. There's also something called proximate cause, which is a combination of the logical cause, which and a sort of a rule of proportion. A farmer who grows the corn and sells it to somebody. This is kind of a joke. What was at the courthouse wall or on a picture at the courthouse, and the farmer who grows the corn that his neighbor bought and turned into corn liquor. The farmer, of course, was part of the cause of the car crash, the result of drinking the liquor. But of course, all he did was grow the corn and sell it. Didn't know what it was going to be used for. So even though he had something to do with the cause, in fairness, the approximate cause concept lets him off. And that's kind of a joke, but that joke kind of lets you realize that there's a rule of proportion. It's not purely scientific, okay? Cause and fact is easier to absorb because it's strictly logical. There's logical causes that occur. But some causes are remote or not foreseeable. They could not foresee that something would happen as a result of their actions. So we don't really use those causes. But the normal things, duty, standard of care, breach, cause and fact, and damages are the elements. So if they haven't proven one of those, they lose and the defense wins. The reasonable person concept is trying to determine whether somebody has breached and whether they have observed the standard of care and things like that. we don't base it on totally subjective ideas like um, saying, well, Bill is very capable and we're going to give him a very high standard of care, and Bob is not very capable, so we're going to give him a low standard of care. We pretty much give them both the same standards of taking care of things. You don't, in other words, you don't get a pass because you're a bad driver. Does that make sense?
Yes.
Yeah. Okay, good. Yeah, it's kind of interesting. Res ipsa loquitur. Um, um, if there's water at the top of the hill, um, and somebody builds a dam that directs it over to another part of the hill, the thing itself speaks. When you find water in the wrong place, it's probably because somebody redirected it. Um, if um, if there's shingles that fell on somebody, um, the shingles probably came off the roof, which seems to be missing shingles. Does that make sense? See where I'm coming from? The reason that we use Latin is actually, I'm not sure if there really is a good reason anymore. It's just because learned professions used to always use it. But res means thing. Ipsa means itself. And loquitur means speaks. The thing itself speaks. So the way things look tell the story is basically it. Um, so even if there's no witness, you can win on an element if it's obvious what happened. Overview of torts. Um, there's intentional, negligence, and strict liability. Strict liability is closely allied to negligence. Um, it's supposedly an easier way to prove liability than straight negligence, but intentional is um, kind of a hard one because it's so closely related to criminal acts that students become mixed up. Don't be mixed up. Don't overuse criminal law when we get to intentional. A lot of people overuse criminal law and they get things all mixed up. Unfortunately, sometimes the same labels are used for both intentional torts and crimes. And of course, they involve the same physical acts. So um, it creates a practical problem um, because people in the public will come and say, um, I got my tooth knocked out and I didn't start it. Can you prosecute the person and put them in jail? And of course, if you are not talking to the police, if you're talking to a private attorney, then it's nothing a private attorney can do to put somebody in jail for doing that. The attorney can say, well, we can sue for money damages. And then the client will typically say, well, he's the kind of guy that likes to hit people in the mouth. And of course, he never has a steady job, has no money. Oh, well, did you go to the police? No, I figured you'd handle that. Well, you should have gone to the police, and maybe you still can. Um, so I got asked that over time. People would say, well, I want this guy in jail. And yes, I had been a prosecutor, so I definitely had very good visual aids or whatever and experience to know the difference between a public prosecutor that works for the county and a private attorney that works for the person that comes in and asks for help. As a public prosecutor, yes, I could have sympathy with victims. I could even ask for something called restitution as part of a criminal sentence, but I could not represent a person and sue for money damages. And my teamwork was much more often with the police than it was with an individual victim. When I became a solely private attorney and did not prosecute anymore, um, then I worked only for individuals. And I suppose you should say, well, what about businesses? Did you work for businesses? Yes, I worked for businesses, but typically individuals. And most of the businesses I worked for were mom and pop businesses owned by usually one person or two. Why is the tort system imperfect? Uncompensated victims. Um, the guy who got hit in the mouth, if he didn't go to the police, he probably didn't collect any money. And if he uh, went to the police and there was a criminal conviction, the restitution probably was just for the dental bills, not for trauma, uh, you know, not for fear or um, mental distress or something. The restitution probably only got paid um, um, $50 a month out of restitution whenever the guy got work. Does that make sense? You see where I'm coming from?
And it actually makes a little bit of sense because if someone gets hit by someone that doesn't have a job and an income, there's nothing really they can do, right?
Yeah, it's of course I know those guys. I I I I definitely worked for the victims, but I also worked for the kind of guys that don't mind getting in fights. I didn't do a lot of work for felons or whatever, people that did major damages or something like that. But I worked for people uh, who worked only sort of when desperate. When desperate, they would get a job for a while. But judges can make them wish they would get a job, but it's and of course, when they go to jail, they can work on you know um, work release. Yeah, yeah. Jessica Dooley has a good point in the chat. Could he hire a private attorney for those damages? Yes. Um, he just couldn't ask a private attorney to prosecute criminally and throw them in jail. Yes. Now it does happen sometimes. Let's say that I went to a concert and I was upset over the fact that they wouldn't let us in the door. And I said, "When are we going to get in?" And one of the security guards of a celebrity musician punched me in the mouth. I might get $100,000 for that. Do you see the difference? No, I wouldn't probably. I wouldn't be in that situation. I probably would not go to a concert, you know, with one of these rough and rugged celebrities who have out of control security people or whatever. I probably wouldn't go to that, but somebody would. And yeah, if some out of control celebrity big shot or their security guard takes a punch at somebody, uh, there may be big damages. It's just that's very rare. You could work for a personal injury lawyer for years and years and never have that happen. Almost all the time, it's going to be suing for negligence against somebody who has insurance. Who has taken civil litigation? Sort of knows this already. Okay. Um, I would say that there are more stages than this, but these are 3 stages after investigation. I suppose you could say these are 3 stages. Pretrial, which at least in my state, pretrial is about the whole thing. And the beauty of that is that very uses much paralegal work at a high level. So civil actions, both sides. Um, the pretrial involves lots of paperwork, lots of information gathering, and lots of information sharing required by law. Information sharing required by law is called discovery. And that is frequently the only part that happens. Um, I've been to the last few bar association meetings in my state of the state bar, and then also the district bar association. I just attended this morning and early afternoon, but in my state, almost all civil actions settle before trial. Now, some of them though go through something called mediation, which you might think is similar to a trial. It actually is not that similar to a trial from the lawyer's point of view. Um, but when I say that settle instead of going to trial, it doesn't mean that they're not prepared for the trial. They may be fully prepared and settle on the courthouse steps. The civil actions that I worked on, we basically had to be about 99.9% ready for trial, or I'm tempted to overdo it and say, well, we're 110% ready for trial. Well, logically, you can't be more than 100% prepared. You're either 100% prepared or slightly under. I would say 99% because we hadn't issued the subpoenas for trial, usually when we settled. Um, now, I'm old enough that I was there when you did try more cases. I tried some cases that you might think were fairly small, but they were very big for the parties. Um, you know, but not personal injury ones. I usually referred the personal injury ones, but I worked with the lawyers that did them, and those settled before trial. But some of the commercial matters, uh, the contractors versus people. Um, I worked for a contractor in one of them, and I worked for other folks in other ones. You know, we sued for just to get medical insurance to pay. In one case, we had to sue um, a bunch of people, and it got kind of complicated. And of course, there were other ones, all kinds of interesting ones, but the ones I handled tended to be the more technical commercial ones, and um, different areas of law that are uh, contract based, or they may be tort based to some extent. But um, this brings up the negligence again, and the strange one that we will tackle more depth later is proximate cause, and like I say, that is logic plus an element of, I would call it, a sense of proportion. Um, that's why I kind of use that humorous illustration of the farmer growing the corn that was made into liquor that was sold to somebody who then became a drunk driver who injured somebody. At some point, it's not proximate, it's not close enough to the incident to make it fair to hold somebody partially liable, even though logically maybe what they did contributed to some extent, but it's not it's not helpful, it's not fair to consider that they caused it. Um, your written assignment is about slip and fall, and create interrogatories. Interrogatories sounds complicated, but it isn't. What is an interrogatory that I would want a paralegal to draft? it's an open-ended question. Do not ask a closed-ended question. Do your own questions. Do not do auto accident ones. The sample document is just for formatting only.
I had a question about the interrogatories assignment.
Yes.
It's in the instructions, if I recall, it specifically says in a 2 to 3 page document, but in interrogatories, there are about a page and a half of essentially definitions and instructions of how to fill out interrogatories. Do you want us to intentionally leave that out so it minimizes it down to 2 to 3 pages, or is it just simply 2 to 3 pages of what we have typed, which will probably end up being more like 5?
I would say use as many pages as you want. The guideline would be more towards you shouldn't need to do more than 3 pages of your own typing, probably much less, okay? Of completely new information. The questions are just numbered questions, okay?
Right, but when you do interrogatories, there's like like definitions of everything, like,
Right.
at the
Yeah,
beginning of it. So do you want us to leave those in or out?
leave them in, yeah.
Okay.
And I am not I'm not I'm not the person who tries to get you to shorten things. I'm the expansion person, expand your thinking person. Um, some of the other teachers will help you edit it down to only the essentials, and I would prefer that you expand on your writing. Does that make sense?
I have a
So,
question.
so so take a skeptical view of page limits if you like to, especially those of you who like to write a little more, or those of you who want to sort of cover all the options. If you, let's say that you did double the number of questions you needed, will I get angry? No. I'll say this student is doing kind of what one of my employees would have done, because if you're not certain what I want, go ahead and do extras.
I have a question just to be clear, because I turned in my assignment, but I just, I, for the interrogatories, I only did, 11 questions. I didn't add anything else to it. Do I need, I mean, other than, I added my analyzing the slip and fall and so forth with the elements and the
Mhm.
issues, but are you saying that I'm supposed to find an interrogatory already made up and then change those questions and put mine? And so that way it has all the format of what goes to the court?
No, you don't have to do that. The assignment has its own format, as I recall.
Oh,
It
did
seems
I?
to me the course creator created a format, so the simple way is to use that person's format, but then don't overuse it.
Okay.
I'll go to the assignments because the usual problem is that students overuse that or they use somebody else's canned one. And I don't want you to use any canned one at all.
I'm looking at the assignment right now.
It's a link. Yeah, it gives you a link to the Library and Learning Services, which has a sample interrogatory, but we don't want to use those literally.
Oh, so I need to redo what I turned in then, because I
No,
just
you
put
don't.
questions.
You don't. Um, the reason that you might have to redo it is if you did what many students do and did yes no questions, because you only get points for open-ended questions. And I'm very strict on that. I'm not strict on the other stuff because when you work in a law firm, the format is not a problem.
Mhm.
They all have them.
Okay.
The other side sends things already formatted. Your lawyer that you work for, um, unless this is the first time they've ever been in a civil case, in which case you can get one from the courthouse, but um, they would have a one that they used in the past. So your formatting is not a problem. The problem is that most people, unless they really work at it, will ask a bunch of close-ended questions, and those don't help. Lawyers do that all the time, and they're wasting their interrogatories.
So
It's a
can I, so
waste
like
to do those.
so asking what the customer count was at the time of the incident, that's not a very good question because that's a, is that a, because I would want to know like how many employees were working at the time. Like, would that
If you
be
ask
important questions or?
if you ask for how many employees were working, um, and uh, and then ask what are the names of the employees, um,
Oh,
then you are asking open-ended questions. If you say, um, did an employee observe what happened? And if so, which one? Then you're wasting a question because the rules of most states are going to call that two questions. You've used up two questions when you could have only used one.
okay.
Um,
All right. Then I'm gonna have to go and adjust. Okay. Thank you.
yeah. The other thing is students, most students are a mom or a dad, and they'll ask a mom or a dad yes or no question, sort of like my mother-in-law used to. She'd say, um, well, um, did you play 18 holes of golf today? And of course, the answer was no. She got no information from me then. Then she'd say, well, did you play 9 holes of golf with a friend? No. And well, you left in your golf stuff. You brought your golf clubs. Didn't you play 9 holes of golf? No. Well, I had gone to the driving range, but she could not bring herself to ask an open-ended question because she was afraid her son-in-law would then explain. She didn't want an explanation. She wanted a yes, no, and then she could go have her coffee or whatever. You see where I'm coming from? She didn't want new information. She wanted me to confirm something that she thought she already knew. Well, that's not the purpose of interrogatories. Interrogatories, we want brand new information. An interrogatory would probably say, what did Mr. Olson do after he left the house in the afternoon? Okay. That way, if I'd have gone to the grocery store, I'd have to report, well, I went to the grocery store and um, I didn't get back till 4 because I was a witness to a slip and fall. Okay.
You
But
made a
just
comment about,
so don't ask if you can logically answer the question yes or no, it's not an interrogatory that I agree with. Um, and lawyers who do those are wasting a question. That's what I'm telling you. And so I don't give points for that. Where lawyers need good paralegals is to help them stop doing that.
so you made a comment about if you wanted to go essentially beyond, above and beyond and do more than the 3 pages or, whatever. Um, are we going to be worried about the procedural rules regarding the maximum amount of interrogatories we can use per your state, or are you not worried about that and you can pretty much do as many as you want? Because I think in my state, I think the maximum is 30 or 40, which I don't plan on doing that many. I'm just
No,
curious.
no, you don't have to do lots of extras. And I'm making you aware of this so that you know that what I'm requiring is based on actual useful information, okay? It actually helps win if you learn to, not just you personally, but you and all your classmates, if you work hard on getting these open-ended questions out there, and it'll help in actual work. And like I say, if they have a limit of 30, or even if they have a limit of 50, with a big case, you may want to ask more than 50. Although, again, do you really have to ask 50 if you ask open-ended questions? But the whole purpose of discovery is so that there isn't something called unfair surprise at the trial or in the negotiation even. You're not supposed to be totally surprised. But if you don't really work on what I call the journalist friends, the questions, then you really don't get full information. You get yes or no's that are dead ends. There is something called request for admission, but those are not called interrogatories, and that's a separate document. Lots of lawyers don't even, well, they know about them from law school, but they've forgotten about them. And when they come up against a uncooperative opponent, if they've forgotten about those requests for admission, they don't know how to pin down the opponent after they've asked all the interrogatories and gotten unsatisfactory answers, or if the other lawyer refuses to agree on a simple list of bills and costs. Lots of times lawyers on the other side will cooperate because it's just a waste of time, both clients' money, not to agree on things that are obviously going to get proved, and there's no way to stop them from being proved. But just for delay purposes or just because of their personality base, they will not agree to things that common sense should make them agree to. And then you do ask them yes/no questions. Do you agree that this is a true and correct copy of the hospital bill and that my client owes $15,370? And you can even remind them, by the way, we have given you an authorization to talk to the hospital billing department in case you doubt us, okay? And if they have common sense, they'll agree to it. But if they don't agree to it, that and other little stuff, not little exactly, but other important stuff that's obviously should be agreed to, then we can ask them the close-ended questions, but that's a separate document, okay? And like I say, lawyers have forgotten because they've not dealt with some of the stinker attorneys very much. Yeah, admissions. But a request for admissions, that is yes or no, but what we're doing is not. If you read through it and you say, this one could be answered yes or no, then rephrase it. The other thing is you can do one that's more of a demand than a question. Provide a list of witnesses and other people in the store at the time of the incident. And you might say, well, why do you ask for other people in the store? Because they may not think that they were a witness, but they may have heard something even though they didn't see it, things like that. You can ask them, and technically this doesn't seem like a question, but it's allowable, okay? We can ask for lists, but you absolutely need to make them open-ended questions. Like I say, if they're all open-ended, you won. Even if I don't like your format, or you didn't do a format, even if you did more than you were supposed to, that is fine. If you do two close-ended questions, but then you do extra open-ended ones to make sure that you get it done, you still won. Once you gain your points, you don't lose them. So let's say I have a student who does everything I want and then does some extra stuff that I really didn't want. Once they gain their points, they don't lose them. Another one is the students that had difficulty phrasing something in formal language, but they have enough correct grammar and spelling on the other stuff to where they've already earned their grammar spelling points. They still won. Once you win, you don't lose. Does that make sense, folks? I don't take off points. You either earn them or you don't. Once you've earned them, you keep them. Why does that help? It helps because if you provide some speculative stuff at the bottom of the page, stuff you're not sure of, you might do what you would do in a law office and say, can we ask this question? What insurance do you have for slip and fall? What insurance do you have for automobile? Even though automobiles are not in it, you may think that do you have what kind of other policies do you have that might be used, such as a umbrella policy? And you don't even know if a business would have something called an umbrella policy. Probably wouldn't. But if you ask extra questions that turn out not to be workable, you haven't lost points. So I'd rather have you use your brain more and do more, you know, rather than hold back. Hi, Walker. Welcome. I'm talking to my students right now. My grandson just came, so say hi to Jessica, Rachel, and Yamalitza. Say hi, Walker. Yep.
Hi, Walker.
Hi. Hi.
Can you hear him? Yeah. He can hear you. Thank you. Go find your daddy. I have to finish this, okay? Okay. Anyway, you can ask for lists. You can use the case caption provided or research for your state's case captions. Ask something specific about the fact that it's a slip and fall. It should not be too generic. I'd rather have you come up with your own questions that you're not satisfied with than to use canned ones that you find. Use your own questions. It builds skills better. Building skills is the biggest part of this. Finding questions is not really useful for you. Those will always be available if you need them for a slip and fall case later when you're in legal work, but you won't have time to work on your own skills as much as you do now. So really work on skills. We don't want you to get affirm and deny ones for this. Here's a bad question. Were you at the premises at 9 a.m. on January 3rd, 2020? Because then they would just say no if they were there at 9:10. In casual conversation, or if you're talking to one of your kids, they wouldn't get by with saying, no, I wasn't there. You'd say, well, you should have volunteered that you were there 10 minutes later. But lawyers and the other side doesn't, they will not get punished for just saying no if you ask them that kind of a question. And I got a question. Please provide a list of any insurance policies you have in place. Yeah, that would work. I would say I would be a little more specific than that just to get it a little bit more about slip and fall. That may cover premises liability or slip and fall. The more you put it in your own words, though, the better. Okay. Yeah, I get you. There's zero educational value in using canned questions. Don't use ones you've used in a job. In the job market, you in the legal work, if you've done legal work, you probably didn't get to draft your own questions as much as I want you to. I want you to be able to draft questions when there are no forms because it's an oddball case. That's not very similar to other ones that the law firm has ever handled. I mean, I handled, give an example, I actually handled a case that involved the Federal Aviation Administration, even though there's no major airport for at least 60 miles from my house. And you say, well, why would you get involved in that? Well, it was a little small plane, local plane. Well, there would be no forms to use for a case like that. You have to come up with your own questions. And that's going to happen all the time. How about one that involves liability for selling bad seeds? Then that could happen either with farmers or with even with homeowners that are gardening or something. There's all kinds of cases that could happen that are not standard. Journalist friends are this: who, what, when, where, how, and sometimes why. So it's all the W's and the H. Just think of the W's and the H, and I would write those down: who, what, when, where, how, and why. And I've had lawyers tell me you can't ask why. Yes, you can. You might want to put those in red for the lawyer and say, do you want why questions in here? But suggest them. Because sometimes you get at something with a why that will help. And a good example of a valid why question might be in a why why were you cleaning the floor at that time in that place? Don't worry about perfect. If you worry about perfect, it ruins your product and your skill building. I've seen too many people that worried about perfect and then they made silly use of somebody else's product and they didn't learn anything. So perfect is not in there for this at all. I would rather see a poorly phrased, overly general question you draft in your own way, even though you can't think of a formal, legal sounding way to do it. That's actually much better. A slip and fall is not a auto accident. And I'll show you what the example is. I think what I'll do is I'll screen share. Is that okay? Screen share?
Yes.
Share screen. Let's see. I got too many screens up. I got to get rid of some of the stuff here. Let's see. Let's get rid of that. Let's get rid of these. Too many choices. Okay, let's screen share. If you want to screen share sometime yourself, you may. But anyway, this is the assignment itself. And this tells you how to find cases so you can figure out what a slip and fall case is. And this is what are interrogatories and can I see a sample? And then you get to this and you say, well, oh, this is a sample document and formatting. But again, yes, you may use these, but don't take them literally. Don't get sidetracked into auto accidents when we're not dealing with an auto accident. I don't know if I should try to open that or not. If I do, you probably won't be able to see it. Can you see it? Probably not.
We can see it if you touch it. Yeah.
Oh, the Microsoft Word document?
We can see it right now.
Yeah, and see, this one has driver, and so it's all about auto. So we don't want all this auto stuff, and we don't want any of their canned questions. Even if they look good, I want you to just draft your own. The more you draft your own, the more points you get for good reason, because it's skill building. I'm a skill person, not a perfect person. It's a big step up to do your own drafting, put it that way, and it's not a big step up to just find stuff. So when did the fall happen? That works. Did the fall occur at 4 p.m.? No points. Who was present? That works. John, Dave, Mary, and Joan were the only ones present, correct? No. Like I say, after they lie about, and they don't list Joan, you can say, please review the statement Mary made about being a witness. Please admit or deny that Mary was actually present with John, Dave, and Joan. Okay. But that's a different document, not the one we're doing. So it's not useless to know how to ask yes or no. It's just that's the yes or no's are easy. You don't really have to learn them. Lawyer doesn't need much help with the yes or no's. They're really good at that, but sometimes they're not very good at this. You do not, the other one that irritates me, even though lawyers do it all the time, was anyone present? If so, list them. Skip this one. It's just a waste. You're wasting a question. Ask who was present. Don't ask whether anyone was present. What question? Why question? How? Those work. How did you respond to it works. Did you render first aid or assist the plaintiff? No, you don't ask that. They need to volunteer that. Otherwise, we're just prompting them. Do you see where I'm coming from? Don't prompt them. Don't tell them what to say or what to think and then ask them to confirm it. Like I say, if they lie or they're uncooperative, you can later on use a different document. But in this case, we're going to ask them as open-ended a question as you can stand. The discussion, you don't have to respond to 2 classmates. 1 is sufficient. I'd rather have you do 2 because it's more fun, but 1 is enough. Current. The biggest problem with this is it's kind of the same problem with interrogatories, is that I get a canned answer because there are 1,000 canned answers that are available about Helen Palsgraf versus the railroad company, and all useless in skill building. I've never known anybody that built skills by just typing in Palsgraf explanation and then copying it. That's so useless. I think my 4-year-old grandson could probably talk into his dad's cell phone and say, I don't know how to say Palsgraf, but explain Palsgrafs that Grandpa's talking about, and it would probably spit out some kind of a legal answer. But obviously nobody would have, there would be no thinking involved. Do you see where I'm coming from with that? It's not find and memorize, it's think for yourself, in other words. I'd rather have you be wrong for your own reasons than right for somebody else's. When you're working in legal work, you can always find out what the attorney, and eventually you find out what the other attorney thinks. You can eventually find out what the judge thinks. All fine. But I want you to volunteer to the attorneys what you think. Now, some lawyers would say, well, why don't you keep that in your notes and I'll ask you when I want to. Well, fine. But I want you to have notes either in the regular paper that the lawyer asks for. I want you to put your opinion in it. And if the lawyer does not want that for some cases, have it in your personal notes, also in PDF or Microsoft Word. You're paid to think as a paralegal, in other words. If you're not, get a different job. I wanted to know what my employees thought, even if they were not at the level of a paralegal. I had a high school girl working for a while just as kind of an intern, just to kind of get used to office work. And I wanted her opinion because she could probably come up with something from a different perspective, even though she only worked for a short period of time, to part-time for us. But she may pick up something that somebody else missed. Do you see what I'm thinking about, or how I'm thinking about this? Not like other jobs. I think somebody unmuted. Okay. Yeah. The other thing is, as we progress in the course and as you do the discussion, try to clearly divide your thinking from what you found. And we will work on that with citation and use of sources, but we also will work on it with tables and citations. So zone of danger and proximate result of negligence. It's kind of strange because in today's world, our zone of danger, our perceived zone of danger is huge. You go into an airport and you feel like the entire airport must be a zone of danger, because they're checking for mad bombers at every entrance. And every item of luggage is supposed to be checked. I mean, gone over. I realize, yeah, checking is technical, of course, check luggage versus carry-on. But every bit of luggage, even a person's pockets are supposed to be emptied, everything, right? Well, in the 1920s, it wasn't like that on like the train. I suppose there was probably just a sign saying if you're bringing hazardous materials, let us know or something. But I don't even know if they had that. Nowadays, if you go on any public transportation, you're strictly prohibited from bringing a list of things along, and you are subject to inspection, anywhere. They just cannot bring stuff, but things were kind of wild and free back then. People relied on common sense. A few years after the incident, my dad and my uncle used to walk to school with their hunting rifles, and they would park the rifle outside the schoolhouse door at the country school. And then when they went home, they would hunt on the way home, maybe hunt squirrels or something. Nobody thought anything of it. It was nobody thought that anybody would use a gun illegally, that a school kid would do anything wrong. Does that boggle your mind? That was the way people lived in the into the 1930s. Nobody in the country, people never, there were no incidents. People would, if somebody brought a toy gun to school now that looked like a gun, the kid would probably be expelled, and the parents would be in jail temporarily, and the entire town would probably meet to figure out what's wrong. It's a much different, you know, we live in a much different culture than we did back then. Like I say, people that I knew and were around when I grew up experienced a much different world than I'm experiencing now. One of the things that helps is to find a modern interpretation of Paul's graph. Here's one, and I also put one into the discussion, but it kind of helps you decide. The thing is, things like zone of danger and proximate cause still matter, but they're going to be interpreted according to what is a reasonable person in today's world, right? Reasonable, and person includes corporations like railroads. Reasonable railroad corp. Different now, but the concepts still work, right? Okay, questions, problems so far? And so you can, when you do it in Lexis, it's easy to get to related cases. And you can exclude it to where it only goes for positive caution ones, and then you can ask it for only brand new cases. You can do it based on years. So would you like me to show you? I can show you how to do that.
Yeah, why not?
Okay. You can narrow by treatment, jurisdiction, head notes, timeline. I like head notes and so instead. I think that's kind of where I'm going to go with this. Let me, I think I will open up Lexis and then do that. I realize I'm going a little bit long, but it's worth doing to get you started. Because if you can use Lexis, you can find home state stuff that makes sense and that is more practical for what you're doing at work or what you will be doing at work. So we go to Lexis and then we can find by citation. So let's find the wrong Paul's graph case. And you say, how can it be the wrong Paul's graph case? It's because this one is just an appeal for a new trial and doesn't do anything really. So then we want to go to subsequent appellate history. And you don't want to go to rehearing denied. That's not going to do much. So we're going to go to this one, which is really the main case. the main part of the case, I should say, the main stage. And so you go to the main stage of the case. So first it went to trial court, then the appellate division, and then the highest court in New York is actually not called Supreme, it's called Court of Appeals, and that's this. And then you can shepherdize, and then you can confine it. Actually, I'm going to do it a little bit easier. I'm going to shepherdize it only by, let's say, the duty. Okay, head note 2. Excuse me. Shepherdize narrow by this head note. So, and then you can select a timeline and get just new cases. Then you don't have hundreds of cases. And you can just see how they use the principles on cases that have nothing to do with railroads, or, you know, where they look at a zone of danger much more strictly, or much more, maybe I should say, much more broadly. They think more things are dangerous than what the court did in Paul's graph, of course, in today's world. People believe in the danger more, put it that way. If you wanted to manufacture fireworks, you would have a blizzard of regulations, and you would have to more or less, you would be subject to what's called strict liability, where you have a special duty to make things safe rather than just a duty to be careful. So being avoiding carelessness would not be enough. Basically, if you manufactured fireworks, your obligation is to make things safe. And you say, well, that's not fair. That's so wide and sweeping. Well, then don't manufacture fireworks. Case law is very old, and by case decisions. Legislatures usually do statutes of limitation, but that doesn't give the elements of the case itself. It just says how soon you have to sue. In the past, students mixed up statutes of limitations with the actual torts. That's why we are using the textbook more in this course than you would otherwise, because it's very hard to go through enough cases to get the basics. So the basics are going to come more from the textbook than from like state statutes. So you're going to use the research more for exceptions and for limitations than you are for basics. You're going to use the text more than you would in most courses. I'm going to pause. I'm going to repeat this for the recording people, or people listening by recording. Yes, you do have to type that word negligence in to the live classroom in order to get your points. And then, of course, that's kind of a quiz that you're answering, the live classroom quiz. And then remember that this is a super short week. So normally I like people to call me Monday through Friday, but if you send me a course message today or text me over the weekend, just let me know when I should call you, and we will straighten it out.